Good morning, everyone, and welcome to the second of three presentations on the proposed amendments to the patent rules. This presentation will focus on the proposed amendments related to the topics of examination process and amendments to applications, abandonment and reinstatement, as well as third-party rights and due care. The additional two presentations will cover the remaining 8 topics outlined in the consultation documents. As part of the Canadian Intellectual Property Office's core vision, or CIPO's core vision, to enhance innovation and contribute to economic success in Canada, we are committed to improving the quality of our products and services. In order to ensure that these proposed amendments to the regulations address our clients' needs, the Canadian Intellectual Property Office is undertaking an online consultation process from August 1st to September 8, 2017. In addition to these presentations, 11 detailed discussion documents on the proposed amendments and a draft of the proposed rules are available on the CIPO website. Your feedback, comments, and suggestions on the impact of these proposed changes are an important step to this process and will help support the implementation of the proposed amended rules. This consultation has 3 main objectives: to inform stakeholders of proposed changes to the patent rules, to provide the policy rationale behind the changes, and to obtain feedback, questions, and comments on the draft rules. We will begin by providing a brief introduction on the rationale for the proposed amendments to the rules. This presentation will outline the proposed changes to the provisions of the rules for examination and amendments, abandonment and reinstatement, third parties' rights, and due care. We will conclude with information on how to provide comments regarding this consultation. These changes stem from the government's initiative to modernize Canada's intellectual property, or IP, framework. The government first announced plans in 2014 to join 5 widely recognized international IP treaties: the Madrid Protocol, the Singapore Treaty, the Nice Agreement, the Patent Law Treaty, and the Hague Agreement concerning the International Registration of Industrial Designs, abbreviated as the Hague Agreement. To give a bit of context, these proposed rules were drafted following 2 series of amendments to the Patent Act, which received royal assent on December 16, 2014 in Bill C-43 and on June 23, 2015 in Bill C-59. The amendments are not yet in force. They will come into force once the necessary coordinating amendments to the patent rules come into force. These amendments to the Patent Act and the proposed amendments to the patent rules are required for Canada to accede to the Patent Law Treaty. While the majority of the proposed amendments for the rules are required in order to comply with the requirements under the treaty, other amendments were made to undertake a broader review and renumbering of the rules. The amendments will increase legal certainty, streamline and clarify the Canadian Intellectual Property Office's processes and procedures, and align Canada's patent protection regime with that of its international trading partners. A modernized patent framework will enable Canada to keep pace with leading international standards and benchmarks, in turn helping Canadian businesses stay competitive in international markets by giving them an efficient means of protecting their intellectual property in various jurisdictions around the world. A regime that is aligned with other jurisdictions will also lower the cost and increase the ease of doing business here to the benefit of both Canadian businesses and those looking to invest in Canadian markets. The Patent Law Treaty, abbreviated as PLT, was concluded in June 2000 with an aim to harmonize and streamline the administrative procedures for patent applications and patents. In other words, applicants and patentees will be able to expect the same or similar administrative processes for all jurisdictions for patent applications and patents. There is no change to substantive patent law. What is patentable doesn't change and remains part of domestic laws. At present, the Patent Law Treaty has 39 contracting states, while 59 states and the European Patent Organization have signed but not yet ratified the treaty. Canada signed in 2001 and in 2014 noted its intent to ratify the PLT by making the necessary amendments to the Act. Once the corresponding amendments are made to the patent rules, Canada will ratify the PLT. Some of the major changes to the Canadian patent regime include simplified and standard requirements to obtain a filing date, a notification before abandonment, thereby preventing applicant loss of rights without first being advised, the introduction of a 2-month grace period for restoring priority, and the introduction of a due care standard and third-party rights when certain actions are not completed within the prescribed times. In the next few slides, we will discuss the changes to examination and amendments, abandonment and reinstatement, and third-party rights and due care. Let's begin with the proposed amendments for examination and amendments. Your patent application will not automatically be examined simply because you have filed it. You must formally request examination and pay the examination fee. During the examination process, the patent examiner does searches for prior publications and studies your application to ensure it complies with the Patent Act and rules. The examiner either approves or objects to the application. The applicant, most often through the patent agent, responds to the examiner's objections and requirements. The examiner reconsiders and either approves or calls for further amendments. At the end of this examination process, the patent application can be approved, leading to an allowance and an issued patent. Alternatively, the patent application may be refused, and this decision can be later appealed. Under the current patent rules, the time limit for requesting examination is currently 5 years after the filing date of the application. Where examination has not been requested before the expiry of the 5-year time limit, the application is abandoned and a courtesy letter is sent notifying the applicant. Applicants have 12 months from the date of abandonment to request examination, pay the prescribed fee, and to reinstate the application. Under the proposed amendments to the patent rules, the time limit for requesting examination is being shortened from 5 years to 3 years after the filing date of the application. Where examination has not been requested before the expiry of this new time limit, a notice will be sent to the applicant informing them of the non-compliance and requiring compliance within 2 months from the date of the notice. Where this notice is sent, an additional late fee of $150 will be required. Failure to comply with the notice will result in the deemed abandonment of the application. The reduction in the time limit to request examination reduces overall application pendency before a decision is rendered on the patentability of an invention, thus reducing the period of uncertainty for third parties. Under the current patent rules, the time limit to respond to a notice of allowance and the time limit to respond to an examiner's report are currently 6 months. Shorter time periods for responding to examiner reports exist for applications that are undergoing certain forms of accelerated examination. Under the proposed amendments to the patent rules, the time limits to respond to a notice of allowance and the time limit to respond to an examiner's report will be reduced from 6 months to 4 months. The 4-month time limit would apply to all applications, irrespective of if they are undergoing accelerated examination. A uniform time limit to respond to examiners' reports will reduce the administrative burden on applicants to keep track of due dates. The reduction in the time limit to respond reduces overall application pendency before a decision is rendered on the patentability of an invention, thus reducing the period of uncertainty for third parties. Under the current patent rules, there are restrictions on the types of amendments to an application which are permitted after a notice of allowance is sent to the applicant. An amendment will be accepted after a notice of allowance is sent only if a prescribed fee of $400 is paid, and if the amendment would not require a further search by the examiner nor make the application not comply with the Patent Act or rules. Where the applicant desires to make amendments which require a further search by the examiner, or which would make the application not comply with the Patent Act or rules, they would need to go through a process of not paying the final fee resulting in the application being abandoned, and then subsequently reinstating the application to bring it back into examination before the patent examiner. The proposed patent rules will streamline the process for amendments after allowance. Under the proposed amendments to the patent rules, applicants will be afforded the opportunity to make a request that the notice of allowance be deemed never to have been sent, after which amendments to the application will be possible. Upon payment of a fee of $400 and the filing of the aforementioned request, the application will be subject to further examination and amendments will be possible. Applicants will no longer need to resort to the abandonment and reinstatement process to make certain desired amendments. Amendments to correct obvious clerical errors can be made free of charge after the notice of allowance. The new process for amendments after allowance will need to be followed to make any amendment to an application, including for the correction of obvious errors in the specification or drawings, though there is no fee for obvious errors. Under the current patent rules, the applications cannot be filed in a language other than English or French. Therefore, there are currently no restrictions on amendments in this regard. Under the proposed amendments to the patent rules, if an application is filed in a language other than English or French, the applicant will be required to provide a translation of the application into English or French before amendments to the application will be permitted. For more information, please see the consultation document entitled Examination Process and Amendments to Applications. In the current Canadian patent system, when an applicant fails to take certain actions that are required for the continued prosecution of the application, an application for a patent can enter a state of abandonment. An example of this is when a request for examination is not made or when a maintenance fee is not paid by their respective due dates. An applicant may choose to not take certain required actions because they no longer wish to pursue patent protection and desire the application to be abandoned, or they may fail to take a required action inadvertently. In both cases, an applicant has 12 months from the date of abandonment within which to reinstate the application. The reinstatement function acts as a safety net. If an application is not reinstated within 12 months of the date of abandonment, it is irreversibly abandoned. Failing to take an action by a required due date, such as failing to pay a required fee or to provide certain documents, is a common challenge for applicants. Such a failure may lead to the dramatic consequence of an inadvertent loss of rights if the applicant fails to avail themselves of the existing safety net to rectify their failure. Canadian legislation provides that when certain actions are not taken within the prescribed time limit, the application for a patent is deemed to be abandoned. Currently, the Patent Office notifies the applicant of the abandonment. However, the notice is merely a courtesy and the abandonment occurs by operation of law. An applicant may remedy the failure which caused the abandonment by reinstating the application, but must do so within 12 months of the date of the abandonment. Failure to reinstate an application will result in the application being irreversibly abandoned. The notice requirements in the Patent Law Treaty obligate patent offices to notify applicants of a non-compliance with procedural requirements before any sanction, such as abandonment, can take effect. Currently, in some instances, the Patent Office already complies with the Patent Law Treaty notice requirements. For example, when the application does not comply with certain formalities or is defective in a substantive way, for example, lacking novelty, the Patent Office requisitions the applicant in a notice in the form of an examiner's report to comply within a specified time limit. In these instances, no changes to the notifications are envisioned. However, in certain instances, abandonment of an application currently may occur without notification. Under the proposed new state, where the Patent Office does not currently notify the applicant that an action must be performed, such as when a maintenance fee is due, the Patent Office will notify the applicant and provide additional time within which the applicant must take the action. In the new regime, abandonment can only occur if the applicant fails to comply with the requirements of the notice before the expiry of the time period stated in the notice. Thus, the abandonment will no longer be an operation of law, but will be linked to the notice informing the applicant of the non-compliance. When, for example, a maintenance fee for an application is not submitted in a timely manner, the Patent Office will notify the applicant of the non-compliance. The time limit to rectify the non-compliance in this case will be the later of 2 months from the date of the notification or 6 months from the original due date to comply with the requirement. Similarly, if an applicant fails to request examination in a timely manner, the Patent Office will notify the applicant of the failure and require compliance within 2 months of the date of the notice. Failure to comply with the notice before the expiry of the time limit will cause the application to be deemed abandoned. The new notice regime will cause applications to be abandoned later than they would in the present system, and therefore will increase legal uncertainty for third parties. Because the abandonment and reinstatement regime should be used as a safety net, and in order to reduce the amount of legal uncertainty for third parties, there is a provision allowing for third-party rights that provides a disincentive to abandoning applications. Importantly, third parties who take certain actions during specific time periods could be exempted from actions for infringement of any resulting patent. For a more complete explanation of the third-party rights provision, please see the consultation document entitled Third-Party Rights and Due Care. The remedy to rectify the abandonment of an application is reinstatement of the application. Under the current state, reinstatement of an abandoned application requires the applicant to request the reinstatement within 12 months of the abandonment, pay the reinstatement fee, and take the action that should have been taken to avoid the abandonment. The current reinstatement requirements will remain in the proposed new state. However, the increased time limits provided by the notice and the time provided to remedy the failure while enhancing the safety net for applicants also creates some additional market uncertainty for third parties. In order to balance these opposing tensions, additional requirements for reinstatement of an abandoned application will ensure that the extended periods of uncertainty remain a safety net only used where necessary, rather than a default approach that may otherwise be used strategically in the prosecution of an application for a patent. Therefore, in certain instances of abandonment, the applicant will be required to demonstrate due care in order to reinstate an abandoned application. Demonstrating due care will be an additional requirement for the reinstatement of an application when the application is deemed to be abandoned for failure to pay a maintenance fee. Where an application is abandoned for failure to request examination, demonstrating due care will be an additional requirement when the applicant reinstates the application at a date that is more than 6 months from the date the request for examination should have been made. If demonstrating due care is a condition to reinstate an application, the applicant will be required to provide the reasons for failing to pay their maintenance fee or failing to request examination in time. The application will be reinstated if all the requirements are met and if the Commissioner determines that the failure occurred in spite of the due care required by the circumstances. For more information, please see the consultation document entitled Abandonment and Reinstatement and Notice Regime. Amendments to the Patent Act and rules required for compliance with the Patent Law Treaty will introduce a series of new safety nets for applicants and patentees. These safety nets include increased time limits to remedy certain deficiencies, such as, for example, a missed maintenance fee payment. Increases in these time limits are likely to cause increased uncertainty for third parties. Therefore, new balancing provisions are being introduced to mitigate the impact of potentially longer periods of market uncertainty. These balancing provisions will both encourage timely actions and responses by applicants and patentees, and will incentivize an early reversal of an abandonment of an application or a deemed expiry of a patent. These balancing measures are third-party rights and the due care requirement for reversing abandonment or deemed expiry. Rights are afforded to third parties who, while the patent rights are uncertain, take actions in good faith which would otherwise constitute an infringement. In specific circumstances, third parties will be protected against infringement proceedings when they start using or make serious preparations to use a patented invention after a prescribed period of time has elapsed after IP rights appear uncertain. IP rights may appear uncertain when an applicant or patentee did not take an action that should have been taken during the course of prosecuting an application or maintaining a patent. The availability of third-party rights is a significant departure from the current Canadian patent system, in which there are no third-party rights. While the framework for third-party rights is established in the Patent Act, the precise parameters surrounding the application are primarily provided in the patent rules. The due care requirement is one that will need to be met in certain circumstances in order to reinstate an application or to reverse the deemed expiry of a patent. Whether or not due care will be required is proposed to be dependent on both the type of failure that led to the abandonment or the deemed expiry and the point in time when the failure was rectified. Only when due care is required to be shown, a request to reinstate an application or reverse the deemed expiry of a patent must include the reasons for the failure to take an action and should describe the circumstances that the applicant or patentee was faced with, which led to the failure that resulted in the abandonment or deemed expiry. When due care is required, the Commissioner will make a determination based on the facts of the case as to if the applicant or patentee failed to take an action that should have been taken in order to avoid abandonment or deemed expiry despite all due care required by the circumstance. The Commissioner may ask the client for additional documentation or information if deemed necessary to make this determination. Applicants may need to demonstrate due care to reinstate an application that is abandoned for a failure to pay a maintenance fee and the late fee on time, or a failure to request examination and pay the prescribed fee and the late fee on time, as described and illustrated in the following slides. Due care will not be required to reinstate applications that have been abandoned for failure to take any other action. In the current regime, an application will go abandoned immediately after a maintenance fee is not paid by the due date. Applicants have 12 months from this date to pay the fee that should have been paid and to request reinstatement before the application is dead. In the new regime, when a maintenance fee is not paid on time, a notice will be sent to the applicant requiring the payment of the fee and a late fee. If these fees are not paid before the later of 6 months from the maintenance fee due date and 2 months from the date of the notice, the application will be abandoned. It is proposed that if a maintenance fee due for an application is not paid on time, third-party rights will apply starting from 6 months after the maintenance fee due date. Due care will be required to reinstate the application in the time period beginning immediately after abandonment. In the current regime, an application will go abandoned if an applicant does not request examination and pay the prescribed fee before the 5-year period following the filing date of an application. Applicants have 12 months from the date of abandonment to request examination, pay the prescribed fee, and request reinstatement before the application is dead. In the new regime, applicants must request examination before the expiry of the 3-year period after the filing date. This time period is extended in limited circumstances for PCT or Patent Cooperation Treaty applications and divisional applications. If the applicant fails to request examination and pay the prescribed fee before the prescribed date, a notice will be sent to the applicant requiring this action be taken. If the action is not taken before 2 months from the date of the notice, the application will be abandoned. It is proposed that if an applicant fails to request examination and pay the prescribed fee before the prescribed date, third-party rights will apply starting from 6 months after the prescribed time. Due care will be required to reinstate the application in the time period beginning 6 months after the prescribed date. In the current regime, a patent is deemed to expire if the maintenance fee is not paid within a 12-month period of grace after the fee is due. In the current regime, there is no requirement to show due care after having missed payment of a maintenance fee, and there are no third-party rights. In the new regime, when a maintenance fee is not paid on time, a notice will be sent to the patentee requiring the payment of the fee and a late fee. If these fees are not paid before the later of 6 months from the maintenance fee due date and 2 months from the date of the notice, the patent will be deemed to expire retroactively as of the maintenance fee due date. It is proposed that if a maintenance fee on a patent is not paid on time, third-party rights may apply 6 months after the maintenance fee due date. Due care will be required to reverse the deemed expiry in the time period beginning 6 months after the deemed expiry. For more information, please see the consultation document entitled Third-Party Rights and Due Care. At the end of the consultation period, comments and submissions received will be reviewed. Stakeholders will have another opportunity to provide comments when the draft regulations are published in Canada Gazette 1. During this stage, the public will have 30 days to provide input and comments. The proposed regulations will then be presented to Cabinet for final approval. If approved, the rules will be published in the Canada Gazette 2 with a coming into force date of the Act and regulations. As the proposed rules advance over the coming months, we will continue to engage stakeholders, for example, on the development of office practices and the Manual of Patent Office Practice. This concludes our presentation on the new provisions of the amended patent rules. Should you have any questions or comments on the contents of this presentation or on the rules, you can visit our website for further information. Here you will find links to key information pages as well as current information on the next steps in this process. To learn more, ask questions, and submit your comments or feedback on the proposed amendments, please email us at the address on the screen. In addition, you can follow SIPO on social media, where we will continue to post updates on the consultation process. Thanks for watching.